your signature of Laura's signature defendant. Did you sign this document?
Yes, sir.
When did you do that?
I actually don't really remember the date.
Probably Thursday or Friday last
Say
week.
last week? Okay, all right. Now, when you signed this agreement, we have Mr. White's office?
Yes.
Yes.
Okay. And did he explain everything to you so that you would know what it meant?
Yeah.
All right, and did you have enough time to fully consider this matter before making this decision?
Yeah.
And are you entering into this agreement voluntarily?
Yes, sir.
Now, under the law, normally, when someone pleads guilty, the court finds them guilty and then imposes a sentence. And that usually means that the person is either given probation or free control, or be sent to prison, be fined, or any combination of those items. Now, there is a provision of the law which is what's being proposed to be used here, and that is a diversion program. What that means is that if the prosecutor's office is in agreement and has you sign a contract under which you agree to do certain things, if you complete that agreement with the prosecutor's office, then they will notify the court and the charge will be dismissed. So you enter a plea of guilty, but instead of being found guilty, the court stays proceedings. That means they're just basically inactivated and taken off the docket, are current, and then I wait for a report from the prosecutor's office. And if you perform all of the requirements in the agreement that you signed with them, then they notify the court and the case is dismissed. And even though you pled guilty, you don't have a felony record, because under the law, your felony conviction is not complete. It doesn't occur until the person's been sentenced. So so what this does is gives you the opportunity then, even though you pled guilty, to perform an agreement obligations that you had, and then have the case dismissed. And once the court dismisses the case, I also set a hearing, and 99% of the time we'll go ahead and seal the record because you completed it, unless something happens between the time that the case is dismissed and the time of the sealing hearing. So usually 3 or 4 weeks. So that's the big advantage to you. Now, you have signed an agreement with the prosecutor's office. Okay, does he pay the fee?
He's paid half the fee, Your Honor, is my understanding that he's going to pay the remaining 75 by the end of this week.
Okay, is that correct?
Yes, sir.
Okay. And so you're familiar with what the obligation is that you have with the agreement with the prosecutor's office. I assume it probably needs to include paying any restitution. Was restitution?
Yes, sir, Your Honor.
Okay. All right. Now, that's the big advantage for you. The disadvantage for you, Mr. Kingsholder, is if you plead guilty, and I refer you into diversion, and if the prosecutor comes back and says he didn't complete his contract, so we're terminating him, then the court finds you guilty. And even and basically, the prosecutor has a lot of discretion as long as they don't use any impermissible reason to terminate you. They're the ones who make the decision. Because diversion isn't a right, it's a privilege, and they give you privileges, so they have the right to supervise that. Now, I will set a hearing and find you guilty upon notification if that occurs. And then once that happens, then you would be subject to being sentenced. You don't get to start over and have a jury trial. And in that case, then, it wouldn't be necessarily that you'd be sentenced to prison. You'd still be given community control or probation, or you could go to prison or fine or whatever combination of 4 things is appropriate. You understand that?
Yes, sir.
Okay. Now the agreement states you're going to plead guilty. Well, let me back up. Are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
Don't feel you've been rushed or pressured in any way into doing this.
Yes, sir.
Okay. You haven't changed your mind since you signed this agreement.
Yes, sir.
Okay. Now, the agreement states you're going to plead guilty to the charge of grand theft of motor vehicle under 2913-0281, 4-3 felony. Further states you understand the maximum prison term for that could be 18 months, the minimum would be 6 if prison is imposed. It would be a fine of $5,000. You understand that?
Yes, sir.
And you're not facing any felony charges anywhere else.
No, sir.
You're not on probation, community control, parole, or post-release control for a felony from any jurisdiction.
For felony, no, sir.
Now, I'm still required to explain to you the worst case scenario. That's why we're going over this stuff. So, under the law, if you were to be convicted, and if you were to be sentenced to prison, upon completion of that, the adult parole authority would have the authority to put you under what's called post-release control supervision for a period of about 2 to 3 years, which means that you would be supervised under the terms they set by a parole officer. And if during that period of time the parole authority felt that you had failed to comply, they could return you to prison even though you served the entire term set by the court for an additional period of up to half of your prison term for one or more violations. But if your violation is a felony, then an additional whatever sentence the judge in the new case would impose money, that judge would also sentence you in this case to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively with the sentence in the new case. You understand that?
Yes, sir.
Right now, again, as I explained to you, if you were found guilty, I wouldn't have to sentence you to prison. I could then put you under community control for a period of up to 5 years at a term set by the court. And if during that period of time, the probation department felt you were non-compliant, they would file a notice of that with the court to be entitled to have a hearing. And if the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control, sentence you to 18 months and $95,000. You understand that?
Yes, sir.
Right now, the indictment alleges that on or about March 19, 2021, in Pine County, Ohio, you did with purpose to deprive Joshua Pike of owner property, knowing it made exert control over said property to wit a Chevrolet HHR, property being motor vehicles defined in ORC section 4501.01, without the consent of Joshua Pike, owner, person authorized to give consent in violation section 2913.0281. So that's the charge. Grant that's a motor vehicle. Now, you understand what it is you've been charged with, what the state said you did, when or how they alleged you did it?
Yes, sir.
You discussed that charge with your attorney, possible legal issues, possible pension, might try to raise a trial, possible outcome of the trial with your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yeah.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, other than the agreement to be put into the diversion program, does anyone promise you anything other than that?
No, sir.
I see here on page 2 that the restitution is the amount of $200. You understand? You have to pay that money restitution to the prosecutor's office through their escrow account. They enter payments you make, they'll charge, I think, $5. You understand that?
Do I pay them here? Yeah, I do
You
understand
pay
that.
it at their office, the victim witness office. Yeah.
Okay. I think I've already made like 2 or 3 payments to them.
Okay, good. Right. Now, you have certain constitutional rights you have to understand before I accept your plea of guilty, because again, this is your last chance to just have a trial and defend against the charge. So, you have a right to counsel. Mr. Wagner was appointed to represent you. He wasn't appointed simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So, if you decide that you do not want to plead guilty, you will still be represented by Mr. Wagner to defend you, including a jury trial, if that's what you want. You understand that?
Yes, sir.
And under the law, you do have a right to have a jury trial in this matter, which 12 people will be selected from a group of citizens that live in this county who are summoned for jury duty on your trial day. After they're selected, the evidence will be presented. They'll be instructed on the law by the judge. They will decide whether or not to state proof beyond a reasonable doubt. If you decided you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, and waive in the legal sense means to give up your right to have a jury trial. And then in that case, you would have to hold a court bench trial, meaning instead of a jury, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not to state proof or guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use you have a right to confront witnesses against you and cross-examine your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else would be present. After the prosecutor's done asking questions, your attorney would ask questions as called cross-examination. The purpose of that would be to bring out evidence and help your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, you request court orders to subpoena. That forces those persons to come to court to testify for you, even though you don't want them, or even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you have the privilege against self-incrimination. Means you cannot be forced to give evidence in this matter at any time, including trial. No one ever make you testify. The prosecutor can't, the judge can't, you make that decision. You decide not to testify. The fact that you did not testify, not used against you in any way by any person in the proceedings, the fact only allowed to talk about it except in one situation, and that is if there's a jury trial, you don't testify, and the court will instruct the jury that because that is your right, they cannot consider it to support any person. You understand that? Under the Constitution, you have presumption of innocence, which means you're innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So the burden of proof is on you to try to prove you're guilty. The burden is upon the state to prove that you are guilty. In fact, under the law, you don't have to put on any evidence at all at the trial. You can't, but you're not required. Whether you do or not, the burden of proof will remain upon the state to prove your guilt. A proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and that exercised or invoked all the rights I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits allegations in the indictment, admits that they're a crime, but you committed that crime. That plea waive gives up all the rights that I've just explained for you, except the right to have an attorney, which you always have no matter what your plea is. With that exception, the guilty waive gives up the right to a jury or court trial. The waive gives up the right to confront witnesses and cross-examine through your attorney. Waive gives up the right to use the power of the court to compel court witnesses to come to court to testify for you, the same as the state. Waive gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also waives gives up your privilege against self-incrimination because you're the one saying you're guilty, and that's what you find you guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal, which you think you may have had up to this point in the case. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the diversion program or what your obligation is under the contract you signed?
Yeah, where do I go for that?
For what?
The diversion.
That's the prosecutor's office. That's what you're doing now, where you signed an agreement with them. Then you're making your payments at the victim witness office with restitution, and you got to pay the other $75 for that.
Oh.
Then you'll be supervised by the probation department under different conditions that would normally be required for someone who's convicted. They're less serious, less restrictive, but you still have some requirements to stay out of trouble and things like that.
I just didn't. I ain't never had to do it. This is my first time.
I'm sorry, I can't hear you.
I said thank you. This is my first time.
Okay.
I had to do any of this.
Sure, well, that's all right, no problem. All right, if you have any other questions, feel free to ask. Now, do you have any questions about the charge and possible penalties?
Yes, sir.
You understand those?
Yes, sir.
Any questions about the plea agreement?
Yes, sir.
You understand it?
Yes, sir.
Any questions about your constitutional rights?
Yes, sir.
You understand those?
Yes, sir.
You need to speak up.
I said yes, sir. My bad.
Yeah, that's right.
That's
Just
right.
make sure you're getting recorded here. Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today? You understand?
Yes.
Okay. Is there anything you need to speak to Mr. Wagner about before we go any further?
No, sir.
Do you have any other questions about anything that I've explained to you here today?
Yes, sir.
Is it your decision, Mr. Kingsholfer, to withdraw your not guilty plea, plead guilty to the charge in exchange for being placed in the diversion program as we just discussed?
Yes, sir.
All right, then as to the charge which alleges that on or about March 19, 2021 in this county, you did with purpose to deprive Joshua Pike, the owner of property, knowing that obtain or exert control over said property to wit a Chevrolet HHR, property being a motor vehicle, as applied in ORC section 450101 without the consent of Joshua Pike, or a person authorized to give consent in violation of section 2913.02A1 of the Ohio Revised Code, charged with grand theft of motor vehicle, carrying possible penalty of between 6 and 18 months and a fine of $5,000, fourth degree felony. How do you plead?
Guilty.
Thank you. Be seated. And I did ask earlier that Mr. King, the state consulted with the victim and the arresting officer.
Yes, Your Honor.
All right. Well, the court will then find that on this date, open court, defendant was advised of all his constitutional rights, made an intelligent voluntary waiver of those rights pursuant to Criminal 11. Please accept it for court finds that pursuant to section 2935.36 of the Ohio Revised Code and the order approving that program by filed by the court. There's nothing that renders this defendant ineligible to participate in the program of diversion operated by the prosecutor's office, and therefore grant his request to be admitted into that program. Pursuant to the written conditions that have been approved by the court, a copy of which you'll get from the probation office, verbally with you, Mr. Kingsolver. I will hold your plea in abeyance and stay the proceedings, meaning that will be stopped and be put on an inactive docket pending a report from the prosecutor's office regarding your progress in the program. You're also ordered to pay the court costs, of course, in the terms of that agreement, as well as the restitution. And the court will find that you paid half of the participation fee, and will pay the balance by August 6th. And further orders that you pay any program fees that the probation department may require you to complete as part of your supervision. And they will go over those with you. So as soon as we get done here, you're to report down to probation, tell them that you were pled guilty, you were put in diversion, and then they will make an appointment to go over all your paperwork with you, and you'll be under new conditions. Now, the conditions that I had imposed on pretrial supervision are now over, so you're not under house arrest, but you'll still be required to report in accordance with the new program. So you go down there today, and I don't know if they'll be able to see you today, but let's make an appointment, so I can do that. So the court, as I said, stays the program, or stays the hearing until I get back to the problem. All right, anything further to state? From Pence?
Did you go to probation before you came here?
Yeah, but he asked me to stop back by and let him know what happened and quit.
They sure you have.
That's what I was going to tell him. I went before.
Yeah.
He didn't ask me to come back that.
All right, so just going down there now. All right, thank you. All right, Destiny Wilson.
Problem, just keep it up. Make sure you get that money paid.
I better not keep it up.
No, don't keep up with your form, that's right.
Want to break your honor?
Yes, ma'am. Case number 21 CR 72, State of Ohio versus Destiny Wilson. Present on behalf of the states, Assistant Prosecutor Adam King, present on behalf of Defendant Attorney Jacob Wagner. Are you Destiny Wilson?
Yes, sir.
All right. Ms. Wilson has been indicted in case number 21 CR 72 for receiving stolen property and 5 counts of forgery. This matter is set for a plea here today. And then Mr. King has informed the court that there's a new case here, which would be 21 CR 39. Would be a bill of information. Waiver of prosecution by indictment and a plea of guilty. Now this other charge has not been found over.
That's correct, Your Honor.
All right, now, Mr. Wagner, you talked to your client about this of pleading in both cases here today.
I have, Your Honor, it should reflect on the record, I inherited this from Ms. Witt. As we were going through this original case, with the prosecutor's office, one was coming Tuesday or would be here. So we, so we did a global settlement. I went out last week, spoke to Destiny, informed her of the information, so I believe she's moving forward.
Okay. All right, she put out a financial disclosure form.
I don't know about the new one, sir.
All right, well, as attorneys, you're supposed to have that ready when you want to build information. Always get your financial disclosure form ready and then build information so they don't have to stop and just fill it out. All they have to do is fill it out and sign it. And have it point to the council, in this case, before we go forward with that. So that's part of a financial disclosure.
I apologize.
All right, so you have any change in your financial circumstances since your last time find that I committed counsel for you, Ms. Wilson.
No, sir.
Alright. Of course, we'll go ahead and make this entry subject to your filing that form. Now, Ms. Wilson, under the law, a person cannot be required to appear before this court to answer to a felony until the grand jury of the county has met and returned an indictment against that person. Now, the grand jury consists of 9 people who live in this county who meet once a month usually, or as often as necessary, to hear evidence regarding alleged criminal offenses in this county. They're actually scheduled to meet tomorrow. Now, the grand jury doesn't decide whether the person is guilty or not guilty. That's what a petit jury is for. And a petit jury consists of 12 people who, after they've heard all the evidence, must find the person guilty by proof beyond reasonable doubt by unanimous vote. The grand jury, on the other hand, doesn't make that decision. They just simply decide whether, based on what they have heard, there's enough evidence to believe that the person's committed a crime, but to the point that they should be required to answer or defend against them. And so, in that case, only 7 of the 9 have to make that decision, since it's not a final decision. And so, if 7 people or more vote to indict, then a bill of indictment is returned. That's the charge. And then it's served on you and come before the court. If fewer than 7 vote to indict, then you don't have a charge that you have to answer to. You never have to come to court on that charge. Now, it's not a final disposition. The state has additional evidence. They can go back in the future and present the case, as long as it's done within the statute of limitations, which generally is 6 years on a felony. But in any event, that has not happened in this case. This new case is 21 CR 139. Now, under the law, a person can give up the right to have the grand jury hear their case and agree to go ahead and let the case go forward by what's called a bill of information. What a bill of information is basically it's prepared the same way as a bill of indictment. It simply tells you what the charge is. But the difference is that the bill of information is simply signed by the prosecutor's office, whereas the bill of indictment has to be voted on by the grand jury, signed by the foreperson and the prosecuting attorney or assistant, and then filed. And so that means that the grand jury, you're just saying, okay, I'm going to go ahead and speed this up and not wait for the grand jury. And so I have here a bill of information that says that alleges that on or about June 29, 2021, in County, Ohio, that you know you were under detention or being reckless in that regard, purposely break or attempt to break the detention. You were being held in connection to a felony of the 5th degree to wit, receiving stolen property violation 2913.51. Copies case number 21 CR 72. That's a charge of escape, a felony of the 3rd degree under 2921.34A1. So that's the bill of information. Now, I have been presented then. When did you get a copy of this done, Mr. White?
Last week we came out, last Friday?
Friday. So I have here a form of waiver of prosecution by indictment. This is a form the defendant signed where they're agreeing to waive the right to have their case go to the grand jury instead agreeing to be prosecuted by indictment or by bill of information. And it's in your name and has your case number on it, 21 CR 139. It says, I, Destiny Wilson, having been informed by the court of all my constitutional rights, my right to be prosecuted or waive indictment, being represented by Jacob Wagner, attorney law of Hillsborough, Ohio, to hereby freely voluntarily waive prosecution by indictment, agree to proceed as a matter by bill of information, dated on the 30th, which would have been Friday. And I see a signature there, Mr. Wagner, with his attorney number, and below that, below the date, there's a signature appears to be Destiny Wilson on the line under which the printed defendant. Did you sign this last Friday?
Yes.
Okay. So you understand that by signing this paper, you're agreeing to give up the right to be indicted by the grand jury on this new charge received, and instead agree that it will be moved forward by bill of information.
Yes, sir.
Okay. And you're okay with going ahead and doing that instead of waiting for the indictment,
Yes.
returning to file discovery and so forth, like what's happened in your other case?
Yes.
Okay. Now, I've been then presented with pleas of guilty in both cases. And The first one is in 21 CR 72, which you're charged with receiving plus 5 counts of forgery. And it states you're going to plead guilty to count 1 and 2. And then the form in 21 CR 139 says you're going to plead guilty to the charge of escape, third degree felony. You got that as a third degree felony, but it's a fourth, isn't it? Plead guilty says it's a.
But she's in detention for?
Oh no, it is a third degree. I'm sorry, I misread. It's a third degree felony. All right. Now, each of these documents are 3 pages, and on page 3 there are signature lines. And on each document on page 3, there's a sentence that's typed that reads, "I enter this plea voluntarily," and immediately below that is a line for a signature of the defendant, and it looks like you have signed each of these documents on that line. Recall doing that?
Yes, sir.
Did you sign those last Friday as well?
Yes, sir.
All right. Now, when you sign these agreements, did you understand that it's an agreement to plead guilty in each case, which means there won't be a trial? In either case, the next step will be a sentencing hearing.
Yes, sir.
And did you have enough time to fully go over this matter with your attorney before making this decision?
Yes, sir.
And he fully explained everything to you in each agreement?
He did.
And are you entering into the agreement to plead guilty voluntarily in each of these 2 cases?
Yes, sir.
Okay, now on the first case, 21 CR 72, it says you're going to plead guilty to receiving stolen property, count 1 under 2913.151, and then count 2 forgery under 2913.31A3. Both of those are 5th degree felonies. And it further states that you understand that the maximum penalty for those offenses would be 12 months in prison if prison is imposed. The minimum could be 6 months on each, fine of $2,500. And if the sentences were reported to be served consecutively, meaning one after the other, that means that it could be a total of 24 months plus the fines together could total $5,000. Do you understand that?
Yes, sir.
Now, in the other case, 21 CR 139 says you're going to plead guilty to the charge of escape under 2921.34A1, a third degree felony, and it further states that you understand the maximum penalty for that would be 36 months in prison. The minimum would be 9 months, and there's certain levels in between that, and then a fine could be up to $10,000. You understand that?
Yes, sir.
And if you're convicted of that charge and sentenced to prison, as well as on the other 2 charges in 21 CR 72, the maximum in that case would be 24 months. The maximum in this case would be 36 months. That means there's a total possible of 60 months and 5 years in imprisonment, and a total fine of $15,000 for both cases. You understand that?
Yes, sir.
Now, other than these charges, are you facing any felony charges in any other jurisdiction?
No, sir.
And are you currently on probation, community control, parole, or post-release control for a felony in any
No,
jurisdiction?
sir.
All right, now, under the law, in the new charge, the 21 CR 139, the charge of escape, if you are convicted of that, it is mandatory that you be put under post-release control for a period of 3 years. On the other charge, it is a possible or optional 3 years, where the adult parole board would make that decision. But in this case, escape check case, it's mandatory. So that means that you will be supervised by a parole officer, again, if you go to prison. And once you get out of prison, then parole adult parole will set forth the conditions of your release, and you'll be signed to a probation or parole officer. And if they determine that you have failed to comply, even though you serve the entire prison term set by the court, the adult parole authority will be able to return you to prison and make you serve an additional period of up to 9 months for any one violation if they limit half of your prison term for all violations. But you commit a new felony while you're under post-release control supervision during that 3-year period. Then in addition, whatever sentence a judge in that new case can impose upon you in the new case, a judge could also sentence you to an additional period, in this case, for violating your conditions of post-release control to 1 year, whatever time would be left on that period of post-release control, whichever is greater. If that occurred, that would be served consecutively and sentenced in that new case. You understand that?
Yes, sir.
All right, now, under the law, I'm not required to sentence you to prison for either of these offenses. I can impose what are called community control or probation. And if that happened, that means you would be supervised on a term set by the court, by the probation department, for a period of up to 5 years. And if during that period of time, the probation department felt you were not complying, they would have to file a written allegation back at the court. You would be given a copy of that. You would be entitled to have a hearing and to have an attorney to represent you in that hearing. And if the outcome of that hearing was that you failed to comply, then at that time the court would revoke your control and then sentence you in case number 21 CR 72 to 24 months imprisonment and fine you $5,000. And in case number 21 CR 139, sentence you to 36 months in prison and $10,000, and order that those sentences be served consecutively for a total of 60 months and a total fine of $15,000. Now, do you understand all of that?
Yes, sir.
Now, the charge in count 1 alleges that on or about the period of December 1, 2020 through January 1, 2021, in Huntington County, Ohio, you did receive, retain, or dispose of certain property being checks, property listed in ORC section 2913.71 on the account of Tammy Massey, said Destiny Wilson, no longer having reasonable cause to believe said property been obtained through commission of theft offense, violation section 2913.51. So that's the charge of receiving stolen property, the 5th degree felony, which carries the penalties I just described. Count 2 alleges on or about the period of December 15, 2020, on or about December 15, 2020 in Huntington County, Ohio. You did with purpose to defraud or knowing you were facilitating the fraud, utter or possess a purpose to utter a writing to a check number 1020, and that you knew to have been forged in violation of section 2913.31A3. So that's the charge of forgery, which is also a 5th degree felony with the penalties that I described for you earlier. In the bill of information, I read that 2 minutes ago, the escape. You remember that?
Yes, sir.
Now, do you understand what you've been charged with in both cases, the 2 counts in 72 and the escape charge in 139?
Yes, sir.
So you understand what the state said you did, when or how they let you did it?
Yes, sir.
You understand the possible penalties?
Yes, sir.
Now, have you consulted with your attorney about the nature of the charges, the evidence in the case, the possible legal issues in the case, the possible offenses you try to raise in trial, and the possible outcome of the trial in both cases?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Has anyone threatened you to get you plead guilty today?
No, sir.
Now, on page 2, there are, of each agreement, there are some sentences or lines printed in bold and underlined. And I see in the 72 cases of ink written in. So let me read that to you as it's written on the agreement. This is 21 CR 72. It reads, defendant shall enter plead guilty to count 1 and 2. They will dismiss remaining counts. State defense jointly recommends 6 months incarceration on count 1, and second 6 months incarceration on count 2. Second, the sentence imposed in case number 1 CR 139. Defendant agrees to make restitution to Greenfield Community Market in the amount of $516.77. Defendant agrees to make restitution to Greenfield Save-A-Lot in the amount of $97.03. Then agrees to make restitution to Country Corner Market in the amount of $472.14. So that's case number 21 CR 72. Now, do you understand that agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Right now, in case number 21 CR 139, it's shorter. It reads, defendant shall enter plead guilty to the bill of information. State defense shall recommend 12 months incarceration consecutive to the sentence imposed in case number 21 CR 072. Is that your understanding the agreement in that case?
Yes, sir.
And is anyone promising anything other than that to get you to plead guilty in that case?
No, sir.
So if you add up the recommended sentence of 12 months in the escape charge and 12 months in the other 2 charges, that's a total of 24 months out of the maximum of 60 months. You understand that?
Yes, sir.
Under the law, Ms. Wilson, the matter of sentence is not up to the parties, it's up to the judge. So even though there was an agreement from the parties as to what the sentence in this case should be, if you plead guilty, I'm not required to follow that agreement. I could decide that that's not the appropriate sentence and go ahead and sentence you to a greater penalty if I thought that was the right thing to do, up to 60 months to understand?
Yes, sir.
And I can also fine you $50,000.
Yes, sir.
All right, now, do you hold any license or certification from any state agency or any kind of a profession or occupation?
No, sir.
You have certain constitutional rights you must understand, or I can accept this plea of guilty in either case. First, you have a right to have counsel. Mr. Wagner has been appointed to represent you in both of these cases. Originally, Ms. Witt had to withdraw from the conflict. But I did appoint an attorney for you simply to have him work the case out. The appointment of counsel is to provide any defense that might be available to you under the law that you wish them to provide. So if you decide you don't want to plead guilty in either or both of these cases, then you'll still be represented by counsel, and he'll defend you through the rest of that case or cases, depending on what your decision is, including any trial, if that's what you want in either or both cases. You understand that?
Yes, sir.
Right now, under the Constitution, you're entitled to have a jury trial in each of these cases in which 12 people would be selected from a group of citizens that were summoned for jury duty on each of these two cases. Once those 12 people from this county were selected, the evidence would be presented in each case, and they'd be instructed on the law in each case. And then the jury in each case would have to decide by unanimous verdict between all 12 have to agree in each case whether or not the state proved your guilt of the two charges in 72 or the single count in 139. And again, that verdict would have to be unanimous, meaning all 12 have to agree as to the verdict in each charge in each case. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up, the right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
The Constitution, Ms. Wilson, in each of these cases, you have a right to confront the witnesses against you to cross-examine through your attorney. That means is that the witnesses in each case would have to come into court, testify in front of you and your attorney and anyone else who's present. After the prosecutor is done asking questions, your attorney can ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence in each of the cases that would be favorable to your side of the case. Do you understand that?
Yes, sir.
The Constitution in each of these cases, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you without mistake. So if you have witnesses you're not certain will come in and testify voluntarily in the case, then you can file a request for a subpoena, which would be a court order, in each of those cases that you want witnesses to come. And then the court would issue that subpoena, and that would order those people to the court to be able to testify on your behalf in either or both cases, depending which case they were subpoenaed in. And that would mean even if they didn't want to come, they would have to come. And that's the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, in each of these cases, you have a privilege against self-incrimination. It means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify in either case. The prosecutor can, the judge can. You make that decision. If you decide not to testify in either or both cases, the fact that you did not testify in that case or cases cannot be used against you in any way by any person, any time. In fact, no one's even allowed to talk about it, with one exception, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider that for any purpose. You understand that?
Yes, sir.
Right, under the Constitution, you're presumed innocent in each case of the charge until proven guilty by the state of Ohio on every essential element of each charge in the case. So what that means is that the burden of proof isn't on you in either case to try to show you're not guilty simply because you've been indicted. In fact, or in 139, you agree to go by prosecution by bill of information. And so what that means is that you don't have to prove you're not guilty. They have to prove you are guilty. In fact, at trial, in either case, you would not have to present any evidence. You could, but you're not required to. Whether you present any evidence in your own defense in either of the cases, the state will still be required to produce such evidence that convicts, or that it convinces the jury or the judge in each case, depending on which type of trial you have. of your guilt by proved beyond reasonable doubt on all essential elements of each of the offenses in that charge or in that case. And that's the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now in case number 21 CR 72, you entered a plea of not guilty. In case number 21 CR 139, you not yet entered a plea. But you could plead not guilty to that as well. A not guilty plea denies allegations in the document discharging you, the indictment 2172 and the bill of information 2139. That plea would exercise or invoke all the rights I've just described to you in that particular case. Now, if you change your plea from not guilty to guilty in case number 21 CR 72 and enter a plea of guilty to the charge of 21 CR 139, that's the opposite of the not guilty plea. Guilty plea admits the allegations, admits that they're a crime in each of the charges set forth in the case, and it waives, gives up your rights in that particular case that I've described for you today, except one, your right to have an attorney. You always have a right to have an attorney no matter what your plea is. But with that exception, your plea of guilty would waive or give up your right to have a jury court trial, waive or give up the right to confront witnesses and issue cross-examine through your attorney. Again, this applies in both cases. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf in the same state. Waive or give up in each case your privilege against self-incrimination, because you'd be saying you're guilty in that case, and that's because you find you guilty in that case. It would waive or give up in each case your privilege against self-incrimination, but if you say you're guilty, the state's not required to prove you're guilty in that case. It also would waive or give up your right to file an appeal in either or both cases, based on any violations of your rights you think could have occurred up until this point in that case. Now, if you're sentenced to a maximum sentence, or under the certain circumstances, you file an appeal that would have to file for 30 days for sentencing after being filed. And finally, a plea of guilty is actually being sentenced in each case immediately by the court. Now, you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, Ms. Wilson, do you have any questions about the charge in the indictment or in the bill of information?
No, sir.
You understand?
Yes, sir.
Any questions about the waiving of your grand jury rights and agreement to go forward on the bill of information?
No, sir.
You understand what you're doing there?
Yes, sir.
And any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
And again, you understand the recommendation on sentencing, not
Yes,
that finding on the judge.
Yes, sir.
Now, do you have any questions about the constitutional rights of this one?
No, sir.
You understand those?
Yes, sir.
And again, any questions about the plea of guilty, what it means in each case, and what will the consequences be in each case if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak to Mr. Wagner about before we go any further?
No, sir.
You have any questions about anything I was explaining to you here today?
No, sir.
All right, then, Ms. Wilson, is it your decision to withdraw your ongoing plea in case number 21 CR 72 and enter a plea of guilty to counts 1 and 2, and to plead guilty to the bill of information in 21 CR 139, according to the terms of the plea agreement in each case that we've gone over here this afternoon?
Yes, sir.
All right, then, as to the charge in case number 21 CR 72, count 1, that alleges that on or about the period of December 1, 2020 through January 1, 2021 in Huntington County, Ohio, you did receive, retain, or dispose of certain property being Shack's property listed in ORC section 2913.71 on the account of Tammy Massey, said Destiny Wilson, knowing had reasonable cause to use that property to obtain the commission of theft offense, violation section 2913.51, the charge of receiving stolen property, a 53 felony, carrying possible prison term 26 to 12 months, fine of $2,500. How do you plead?
Guilty.
As to count 2 in 21 CR 72 that alleges that on or about December 15, 2020 in Huntington County, Ohio, you did with purpose to defraud, knowing that you were facilitating fraud, utter or possessed with purpose to utter a writing to wit, check number 1020, said Destiny Wilson, knowing it to forge, violation section 2913.31A3 of the Ohio Vice Code, charge of forgery, a 5th-degree felony, carrying possible prison term 26 to 12 months, and fine of $2,500. How do you plead?
Guilty.
Then as to the bill of information in case number 21 CR 139, that alleges that on or about June 29, 2021, in Huntington County, Ohio, that you, knowing you were under detention or being reckless in that regard, did purposely break or attempt to break the detention, and that you were being held in connection to a felony in the 5th degree to wit receiving stolen property, In violations ORC 2913.51, Highland County Common Police Court case number 21 CR 72. In violation of section 2921.3481 of the Ohio Revised Code, the charge of escaping a third-degree felony, and a possible prison term of between 9 and 36 months. And the increments provided by law of $10,000. How do you plead?
Guilty.
All right, thank you for seated. All right, the court finds that on this day in open court, the defendant was advised of all the constitutional rights in each of these two cases and made a knowing and intelligent voluntary waiver of the same pursuant to Rule 11. Plea is accepted in each case and is ordered filed. Case number 21 CR 72, the defendant is found guilty of receiving stolen property and forgery for third-degree felonies. In case number 21 CR 21 CR 139, he's found guilty of escape, a third-degree felony discharged there. Now, inasmuch as there's a stipulated recommended sentence, and I would take a glance at the discovery in the 21 CR 72 case, the defendant has previously been convicted of felonies and has served prison term. You serve one term, or do you have two different terms?
Two different terms.
All right, so you have two different.
Yes.
All right. So based on that, the court will go ahead and proceed with sentence. All right. Anything from the state?
Only was the thing of the plea agreement, Your Honor. All victims have been consulted with the are approved of this agreement.
Was there any restitution in 21 CR 72?
There is, Your Honor, I haven't outlined the plea agreement.
Oh, that's right, it was in the plea agreement. And Mr. Wagner, anything you want to say?
Only around, we asked the court to follow the recommendation, taking into light, obviously, breaking detention, when the state code is never something that advise anyone to do. The fact that she has, taken this information, moved the case along, Your Honor, moved the case, I think she barely got, maybe around the corner of the hospital ER room, building where the officer apprehended her, so there was, I believe, not a huge search in this case. I think she was trying to broke the guy across the parking lot. So we're asking the court to go along with the recommendation.
She got out of the building?
I think she was out of the building.
The officer was in front of
No, what happened was she
other than the crime.
she had been at HGH, they walked out of the hospital, and they put her back in the cruiser. She took off on the road.
Oh, I see. She got
So she was apprehended, I think, in the area behind Frisch's Timor Way Airport.
Yes. All right. Yes, Mr. Wright. You stipulating to the amount of restitution.
We're not contesting that.
All right. Ms. Wilson, anything you'd like to say?
No, sir.
How old are you?
I just turned 40.
How
40.
40. Okay. Well, fortunately, I guess it's your third time in being in trouble for, actually, fourth time. It's like 2009, you got received stolen property at 2 years probation. Ended up doing 120 days in an open house. 2010, 2013, 2 counts of forgery, 6 months in each Fayette County. Then theft, Madison County in 2013, 6 months on that. And there's another theft in 2015, but that was a misdemeanor at that time in Fayette County. So based upon that, it's clear that you are a danger to commit thefts against the public and defraud persons of property or stealing their checks and forging them. So it's the judgment of the court that you be and are hereby sentenced in case number 21 CR 72 on counts 1 and 2 to a term of 6 months each to the Ohio Reformatory for Women and Marriage in Ohio. And in case number 21 CR 139, you're sentenced to a term of 12 months to the same facility. Those sentences are ordered to be served consecutively to each other. So we have a total of 12 months in 21 CR 72, consecutive to the 12 months in 21 CR 39. The court imposes those second sentences. The reason that we committed the second count of escape by while we were awaiting trial on another case, and secondly, was committed as separate courses of conduct. So one single sentence of all three of those charges. So one single sentence would not adequately reflect the seriousness of the offenses, and the sentence is not disproportionate to the seriousness of each of these crimes. The minimum sentence of the cases in 21 CR 72 and a 12 months, or possible 36 months in case number 21 CR 139. And also the court finds that your history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public, as I said earlier. Now, in case number 21 CR 72, you're entitled to 37 days for the sheriff to arrest on June 14th of 2021. Is that correct?
Yes, sir.
Right. So that would be a total, and then also there was a 1 day in February you're given credit for. So total of those is 37 days. And the escape charge, there is no jail time credit because you all of it was being put on your case. Now, upon completion of the prison term in case number 21 CR 39, it is mandatory to be placed under post-release control for a period of 3 full years. In case number 21 CR 72, it's optional as to those two charges. Now, it means that at least in case number 21 CR 139, you'll be supervised on the term set by the Delaware Parole Authority for a period of 3 full years. And if they determine under the conditions they set that you have not complied, they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in the new case imposes upon you, the judge would also be authorized to sentence you to an additional sentence, in this case, for committing that to do offense under post-release control for a period of 1 year, or whatever time is left upon 3 years of post-release control, whichever is greater. That occurs, that has to be served secondly to the sentence in the new case. Now, in case number 21 CR 72 is also ordered that you make restitution, and that you make that amount of $516.77 to the Greenfield Community Market, $97.03 to the Greenfield Save Lot, $472.14 to the Country Corner Market. Now, the restitution is a substantive order, and what that means is that a lot of people think, well, if I serve my time, there's nothing more they can do to me, but that's wrong. Under the law, it's a substantive order, and you're subject to being required to pay that until one of two things happen. You get paid, or you die, whichever occurs first. And it cannot be discharged for bankruptcy. And if you fail to make payments, then the prosecutor's office can bring that back before the court, and they can show that you had the means to pay it, and you failed to do so, and you could be subject to being held in contempt and incarcerated for that violation, or there could be other enforcement action taken by the court. And the restitution will be payable through the prosecutor's victim witness office escrow account, and you'll pay any service fees that are charged for that service, which I think right now are $5. So to pay the court costs for judgment, ground, and execution in order in each case. If you fail to do that, clerk collected in those cases by letter on bank accounts, wages, or other earnings that you may have. If that doesn't collect it, then once you complete your prison sentence, not while you're in prison, but once you're out of prison, then the court can order you to do police service in this county and give you credit for each hour you work in an hourly rate set for each hour you work. We'll reduce your judgment by that amount. That's it. All right. Is there anything further? Oh, in case number 172, counts 2 to 4 are dismissed. All right. Anything further, counsel?
Yes, sir.
All right. Your name is Dustin.
Thank you.
Thank you.
May I approach, Your Honor?
Okay. We're going to do a video bond, Mr.
All
All right.
Yes, sir.
All right. Well, we have some more for that. What time did you tell me to be ready up
Right after Mr. Morris.
there? Okay, all right. You can go ahead and go back to President.
If I may inquire, Your Honor, we were going to arguably ask for a sentencing date on Mr. Morris. I don't know if the deputies want to stay or of course will remain him in custody because he is going to prison. We want to ask for a sentencing. Yeah, they want to stick around if he wasn't necessary. If that makes any sense.
Well, yeah, he's on bond, right?
He's on bond.
Okay.
He was just asking for
I
a
haven't that plea agreement yet, right?
Right, so that,
Bring it up and take a look at it. So we're gonna argue sentence over PSI, so
Just say Arthur 612.
there's an agreed upon sentence.
They would get marked out the right.
oh, you didn't, oh, okay, I'm sorry, yeah. Well, you didn't strike out, well,
We didn't mark
got
it
it,
right.
right. Okay. What I'll probably do is, set a sentencing date. Sentence, I'll set a sentencing date and, yeah, so.
I still want to waste
All
resources.
right, you go ahead and go, Deputy Thompson, thank you. Mr. Morris, you're going. Okay, case number 21, CR 59, State of Ohio versus Ashton L. Morris, present for the state, Assistant Prosecutor King, present for the defendant, Attorney Jacob Wagner. And are you Ashton L. Morris?
Yes, sir.
Okay. We need to fax the text out to jail, make sure that they get the,
Attorney form?
you get it to her?
No, but I will.
Okay. So she's already got on me, so we can call out her and get that in. And Mr. Morris is charged with failure to comply for a civil police officer, a third-degree felony, and this matter set for trial on the 12th of the court last week. The parties reached agreement and to schedule set up today. So we both decided before today, we'll go to court and pursue, plus we have another case in the trial. So, Mr. Morris, I've been presented with a plea guilty form, which says you're going to withdraw your not guilty plea and plead guilty. Page, this form is prepared by the prosecutor's office, and on page 3, there is a sentence that reads, I enter this plea voluntarily, and immediately below there I see what appears to be Ashton Morris, on the line under which is printed signature of Defendant. Did you sign this agreement?
Yes, sir.
And when did you sign it?
The 23rd.
Okay. And so, did you do that at Mr. Wagner's office?
Yes, sir.
Did he go over with you before you signed it, explain it to you?
Yes.
Do you understand when you signed it, that was an agreement to plead guilty, which means there won't be a trial, and that's after the case will be sentenced to hearing?
Yes.
Have you had enough time to fully consider this matter before making this decision?
Yes, sir.
This is still what you want to do?
Yes.
Are you entering into this agreement voluntarily?
Yes.
Right now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of failure to comply for a signal police officer under 2921.331B, a third-degree felony. For the states, as you understand, the maximum prison term for that could be 36 months, the minimum would be 9, and certain levels in between the 9 and 36 months in the statute. There's a fine available of up to $10,000. There's a mandatory suspension of driving privileges for at least 3 years. Could be up to lifetime, but at least 3 years is required. And you understand all that?
Yes.
Are you facing any felony charges anywhere else? Are you currently on probation, parole, community control, or post-release control for a prison for a felony?
Yes.
Where's that?
Fayette County.
And what is the charge up there?
Receiving stolen property.
Okay, have you been sentenced on that already?
Yes.
What were you sentenced to?
Community control.
Okay, so you got probation up there.
Yes.
When was that?
Back in, May 24th,
Okay. And this offense was committed,
May 2020.
okay, right before.
No,
They are
a year
minors.
apart
May 20th, this offense is alleged,
of
offense here.
2020,
Okay, when were you sentenced up there?
20.
Oh, in 2020.
Yeah.
Well, this is May 2020 as well, isn't it?
No, I was sentenced in 2021, May.
Oh, okay, all right, so, all right, you were not on probation when you committed this, allegedly committed this offense, okay.
Correct.
All right. Okay. So, if you are convicted in this case and sentenced to prison, and if at some point you get sentenced to prison for violating probation up there,
Yeah.
then that sentence could be ordered to be served consecutively. In fact, it would have to be ordered to be served consecutively under the law. A conviction for the offense in this case has to be served consecutive to any other sentence. So, do you understand that?
Yes.
I don't think it'll be a violation because you were on complete control before
They're still gonna violate me because the indictment come out.
for other reasons. Okay.
No.
Violated, from my understanding, I won't try to contact that attorney. Judge Beathard, I believe, was ordered him to complete the Monday program.
Yeah.
Someone talked to his attorney and
Oh.
see how they can coordinate that, something creative, maybe Judge Beathard would change his entry because he's going to go to prison here, I'm not sure.
Okay. So you understand that?
Yes.
Okay. Now, under the law, Mr. Morris, you're sentenced to prison for this offense. Once you complete that term, the adult parole authority is required under law to put you under post-release control supervision for a period of 3 years. That means that you'll be supervised on the terms that they set by a parole officer. And if during that period of time they determine that you have failed to comply, they can return you to prison even though you've served the entire prison term set by the court for an additional period of up to 9 months for one violation, but a maximum of half of whatever prison term is ordered to be served by the judge for all violations, so there is a limit. But if you commit a new felony while you're under post-release control supervision during that 3-year period, then in addition to whatever sentence the judge can impose in the new case, that judge can also sentence you to an additional period in this case for committing that offense while under post-release control of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively and sentenced in the new case. Do you understand that?
Yes.
Okay. I was just looking at the discovery here. It says you were put on community control for receiving stolen property at Pickaway and got treatment. And then with probation violation, you were through 180 days of money deferral. Then I see there's also says RSP pending, a new case number. So you,
Yeah, I was convicted for it.
okay, you were convicted of that as well.
Yeah.
Okay. All right. Well, just so you know, go to prison on all these charges. They can run one after the other. Judge Beathard sent you to prison.
Yes.
Because of this conviction, they have to be served, at least this conviction has to be served consecutive to the others. You can order those other two to be served concurrently or together. But whatever prison term proposed will have to be served second to this, you understand?
Yes, sir.
Okay. All right. Now, I'm not required to sentence you to prison for this offense. I could impose community control. You're familiar with that, and I still have to explain it to you. Community control means you don't go to prison, but instead you put under supervision of a probation officer, under terms set by the court. And that could be for a period of up to 5 years. And if during that period of time probation felt you were not complying, then they could file a written notification of that to the court, the hearing, and if the outcome of that hearing was that you failed to comply, then at that time the court would revoke community control and then sentence you to prison for the 36 months and fine you $10,000. You understand that?
Yes.
Right now, the charge in this case alleges that on or about May 20, 2020, in Tyne County, Ohio, you operated a motor vehicle as defined in ORC section 4501.01 so as willfully to elude a police officer after receiving a visible audible signal from the police officer and bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to the person's property, violation section 2921.331B of the Ohio Revised Code. That's a charge of failure to comply with the order of a police officer, third-degree felony, carrying possible prison term between 9 and 36 months, and violation of the law, fine of up to $10,000, mandatory license suspension of 3 years to up to life. Now, do you understand what it is you've been charged with, what the state said you did, when, where, how they led you in it?
Yes, sir.
Do you understand the possible penalties?
Yes.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you tried to raise in trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol?
No.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on page 2, there are 2 sentences that have been printed in bold and underlined, and then there's been a number marked out and a number inserted, so I'll read it as it's stated. Defendant shall under plea of guilty to the indictment, state defense shall recommend 12 months incarceration. There's also a sentence that says state defense will argue sentencing has to be straightened out, as I understand it, correct?
Yes, Your Honor.
I'll run through that.
For the record, that was, I believe, my marking of the 18 and 12. I didn't put my initials by it.
States agree with that.
Yes, sir.
All right. Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, Mr. Morris, the matter of sentence is up to the judge. So even though there's an agreement that the sentence to be imposed ought to be 12 months, once I've heard all the information submitted to me at the sentencing, I decide that's not the correct sentence, then I could sentence you to as much as 36 months in prison and fine you $10,000 in addition to imposing a sentence of suspension of at least 3 years up to life for your driver's license. You understand that?
Yes, sir.
Now, Mr. Morris, do you hold any license or certificate from any state, agency, or any kind of an occupation or profession?
No, sir.
We have certain constitutional rights, which understand, Mr. Morris, before I can accept your plea of guilty. First of all, you have the right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that would be summoned to court for your jury trial. After they were selected, the evidence would be presented, then they'd be instructed on the law. And then that jury would have to decide by a unanimous verdict whether or not the state proved your guilt or proved beyond a reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive in writing, and waive means to give up your right to have a jury trial. And then you would have what's called a court or bench trial, meaning the judge is the one who would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
Yes, sir.
And under the Constitution, you have the right to confront witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court, testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to bring out evidence that would help your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to commit voluntarily, your request for issues of court orders called a subpoena and forces those witnesses to come to court to be available to testify if they want them to, though the state, or even though they don't want to be here. Which is the same way the state gets its witnesses to come to court to testify against you. You understand that?
Yes.
Now, under the Constitution, Mr. Morris, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you at any time by anyone in the proceedings. And in fact, no one's even allowed to talk about it with one exception. That is, if there's a jury trial and you did not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused by the indictment. In fact, under the law, you're not required to present any evidence in your own defense. You may, but you're not required. Whether you present any evidence in your own defense or not, burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, originally you entered a plea not guilty. Guilty plea denied the allegation, denied that you committed any crime. That exercise on both all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits allegations in the indictment, admits the third crime, and sure the one committed that crime. That plea wages up all of the rights that I've described for you today, except the right to have an attorney. Always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty will waive and give up the right to a jury or a court trial. It will waive and give up the right to confront witnesses and issue and cross-examine for your attorney. It will waive and give up your right to use the power of the court to compel or force witnesses to come testify for you the same as the state. It will waive and give up your privilege against self-incrimination because you're the one saying you're guilty, and that's what she's finding. It will waive and give up your presumption of innocence because if you say you're guilty, the state's not required to prove that you're guilty. It subjects you to being sentenced immediately by the court, and finally, it waives and gives up the right to file an appeal on any alleged violations of your rights you feel you could have had up until this point in time. Now, if I sentence you the maximum sentence, right under certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes.
Are you a citizen, Ms. Morris?
Yes.
All right, do you have any questions about the charge or possible penalties?
No, sir.
You understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
You understand that the recommendation on the sentence is not binding on the court?
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what the penalty for that plea if you enter here today?
No.
You understand?
Yes.
Now, is there anything you'd like to speak to Mr. Wagner about before we're going further?
No, sir.
Any questions about anything that I've explained to you here today?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge in the indictment pursuant to the terms of the agreement that we just signed?
Yes, sir.
All right, then as to the charge which alleges that on or about May 20, 2020 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from the police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to person's property. Violation of section 2921.331B, Paradise Code, charge of failure to comply with order of signal police officer, third-degree felony, carrying possible prison term between 9 and 36 months, and increments provided by law, a fine of up to $10,000, and a mandatory license suspension of at least 3 years up to life. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court finds that on this day in open court, the defendant provides all his constitutional rights, made no intelligent voluntary waiver of the same. Judge Rule 11. Please accept it in order filed. The defendant is found guilty of the offense of failure to comply with the orders of the police officer of third degree felony as charged in the indictment. All right. When are we thinking about a sentencing date, Mr. Wagner?
May I look at my phone, sir?
Sure.
Or calendar? Actually, how far out do you want to do it? Couple weeks?
Before.
When's the court considering your honor?
August 11th. Actually, August 19th. 1 o'clock.
That'll work, sir.
Sentencing will be then August the 19th at 1 o'clock. The bailiff's going to give you a notice here for that date and time. Now, we're still under the pre-trial supervision, still have your court probation, and make sure you stay compliant, Ms. Morrison. If you remember, I'm not bound by the sentencing recommendation, so if you don't show up, or if you go out and get in more trouble, something between now and then, or do anything stupid, that will have a bearing on my sentence. That's the one risk you take by having a preferred sentence. All right, so get your assignment notice from the bailiff. We'll see you back here at 1 o'clock on August the 19th. Thank you.
Thank you, Your Honor.
All right, now we need to call the jail.
Thank you. Thank you. You good, man?
Looks like he's out there, he's got an officer there looking him up. Do you hear me, Mr. Carr? Okay, I don't have any sound, is there an officer in there with you? They need to turn the volume on your, unit there, jail, could you yell for them to come and do that? There she is.
Can you hear me now, Judge?
Yes, thank you. All right. Case number 21 CR 56, State of Ohio versus Todd Lester Parr. Parr is returned by video from the Justice Center. His attorney is Jacob Wagner. He is present here in the courtroom. And then present representing the state's Assistant Prosecutor King. Defendant was arraigned last week on a charge of failure to register, change of address as a registered sex offender, a third-degree felony. Court went ahead and arraigned him and set bail without counsel present. And since Rule 46 requires we conduct a bond review within 2 business days, he was arraigned on Friday. Matter was set today for hearing. Bond was set in the amount of $10,000 originally, plus service fee costs and the usual conditions. Mr. Wagner, you wish to speak to the matter?
Your Honor, I'm somewhat limited at this time, just to speak to my client. Obviously, I know it's concerning failure to register, so it's an issue with the state. We would just ask the right to file a motion should we see the need at a later time.
All right. Well, the court will note that according to my Ohio Court Network's report, that Parr was sentenced in 2019 for failure to verify address. I assume that was a sex offense registration. He's also convicted of escape. And then in 2017 he was convicted of failure to verify. Along with corruption of a minor in 2010. And so, based on that, the $10,000 this time is the bond the court will remain place. Of course, renew your motion at any time on the case is pending. When you do, the court will review it at that time. All right. So the bond will stay in place, Mr. Parr. $10,000 plus the OR and $171 deposit. If you make them on, you have to report for probation.